The next session is hosted by CMS INDUSLAW. The topic of the session is ESG Considerations in Commercial Arbitration. The session will be moderated by Murtaza Kachwalla and Amrita Tonk. The speakers include Abeezar Faizullabhoy, Mr. DeVitre, Mr. Saurabh Mohindru, and Mr. Vineet Bose. I request all the speakers to kindly take the stage. Thank you.
I am Murtaza Kachwalla, partner at CMS INDUSLAW. I am joined by my colleague Amrita Tonk, and we are delighted to be moderating this panel on ESG considerations in commercial arbitration. ESG. ESG refers to environment, social, and governance. It provides ESG is basically standards which determine whether a company or any organization operates in a socially conscious manner. There are three criteria. You have the environment criteria. It basically is how the company performs, takes steps to protect the environment. You have the social criteria, how the company manages its relations with its employees, suppliers, customers, and the community in which it operates. You have the governance criteria, which basically deals with how the company deals with its leadership, shareholders' rights, anti-bribery policies. Why really are we discussing ESG today? It has gained significant importance, and it is one of the most important factors which the companies, it really determines how the company operates and how investments are made. Earlier, ESG principles were merely voluntary. They were a nice to have matter on the company mandates. However, these are now binding on companies, they are mandated, and they are now becoming legally enforceable. It is on top of the agenda of many of our clients. As you are aware, arbitration is one of the preferred modes of resolving commercial disputes internationally, and we are seeing ESG disputes frequently being referred to arbitration. ESG has gained prominence and a significant importance in company matters. It affects their reputation, their values, and the relationships with communities. In today's discussion, we will explore how ESG considerations are influencing commercial arbitration, from the kinds of disputes which are being referred to procedural interventions, arbitrator responsibilities, and expectations from the parties and institutions. To discuss this topic, I am privileged to be joined by an outstanding panel of experts. We have Mr. Fredun DeVitre, who is a senior advocate practicing in the Bombay High Court. He has over 48 years of experience, essentially in civil litigations and commercial arbitrations. He has regularly been appointed as an arbitrator by the courts. He has represented many clients in international commercial arbitrations. Interestingly, he was a radio and television cricket commentator for test matches, one-day internationals, and national level championships. And he has conducted a popular program called Sports Roundup on TV for several years. He has also presented programs at the Asian Games. He has edited books on cricket. He was also deputed by the International Commission of Jurists, Geneva, as an observer at the trial of Zanana Gusmao at Delhi, East Timor. We are really thankful to have you here, sir. We also have with us Mr. Vineet Bose. He is the head legal and senior vice president at Adani Cements. He looks after highly sensitive sectors like mining and cement. He has handled complex regulatory matters like environmental and forest clearances. His insights will be vital in understanding the on-ground operational challenges of ESG.
Hi, good morning, everyone. I am Amrita Tonk, your co-moderator for the session. I will be introducing the remaining members on our panel. We have with us Mr. Saurabh Mohindru, who is the Chief Legal and Risk Officer at Godrej Properties Limited, a law graduate from Maharishi Dayanand University. He brings over 18 years of experience in litigation, real estate transactions, corporate advisory, and risk management. Since joining Godrej in 2014, he has held various leadership roles and currently heads the legal, secretarial, and risk functions guiding the company's legal strategy, governance, and risk assurance. We are delighted to have you on the panel, Saurabh. Thank you for taking out the time. We also have with us Mr. Abeezar Faizullabhoy, who is a senior partner at CMS INDUSLAW's dispute resolution practice and is based out of the Mumbai office. He brings over 35 years of experience spanning dispute resolution, arbitration, and corporate commercial transaction as well as advisory. His dispute practice includes representing both domestic and international clients across sectors such as manufacturing, technology, services, and retail before the Supreme Court, various high courts and tribunals in the country, and in both domestic and international arbitration. He has also handled numerous matters under the Insolvency and Bankruptcy Code and regularly advises and enforcement of foreign decrees and arbitral awards in India. In his corporate commercial practice, Abeezar has advised on joint ventures, angel and private equity investments, shareholder, share purchase agreements, tech transfers, and issues under FDI regulations and Companies Act, FEMA, as well as other commercial laws. Thank you for joining us today, Abeezar. We are joined today by a distinguished panel of experts who bring with them deep insights from law, policy, and practice perspective. So without further ado, let's dive into this intersection of sustainability and dispute resolution and unpack what it means for the future of commercial arbitration in India. My first question will be to Mr. Saurabh Mohindru. It is widely known that Godrej Properties Limited has made sustainability a core part of its identity, integrating environmental and social responsibility across its real estate projects all across the country. Saurabh, my question to you is, what, in your opinion, are ESG considerations? How and why is it important? And how is it suddenly that it's emerging rapidly? What, in your view, is so critical about ESG that it impacts the reputation of an organization?
Thanks, Amrita, to choose me for the first question. As real estate industry and as a developer, there are a lot of considerations that we incorporate in our projects, which I'll come to later. But I would first want to touch upon how Murtaza has introduced this concept. It's a very nascent concept at the stage, which is picking up very rapidly, globally, I would say, not just in India, but globally. And India has taken few very, important steps, making it, enforceable in a manner. See, for example, like he explained that it comprises of environment, social, and governance, right? See, corporate responsibilities is nothing new as a concept. Corporates has been accountable and responsible for longest period of the time. Historically, these things were in the nature of financial clarity, transparency, legal compliances, and shareholder right protection and all that. But lately, what we have observed is that it is becoming very rapidly towards these integration of environment, social, and governance considerations are getting involved in business. Now, why is it important? To me, as a corporate, I would say it is important because ultimately, this is the planet that we are at, right? Environment is the biggest consideration that we must have. Coupled with that, of course, how people incorporate in your business. How do you treat them? It's widespread when it comes to everyone contributing towards your business. There are a huge amount of laborers involved in our industry, where any project that comes up, it's a 5-year cycle bare minimum to deliver a project, where every stage human intervention is involved. And governance, of course, is something which is a pillar of a transparency for any business that needs to proceed today. Why it is becoming so rapidly growing these days, because there are a few things which are very important. Social awareness is one thing where your customers, your investors, your end users have become very aware that how you are doing your business and ultimately delivering a product, what is it costing to the nation, to the planet. That is where awareness has played a big role for it to become a concept which is becoming so prevalent. Now, when we talk about we as a business, of course, we've taken few steps which we believe are very important for future of the company or maybe real estate as an industry. See, for example, now we have decided that any project that we do will be green certified project, bare minimum with a silver rating. None of our projects which are coming up from past 2-3 years are not green rated. We are shifting to renewable energy. We are buying green energy. We are coming up with projects which are zero waste discharge. Recycling of any discharge, any waste that comes out of our project, that is getting segregated. We have specific vendors who are doing it for us, and there is a complete audit process, first internal and then external, that we follow to ensure that at least what we are doing is meaningful and culminating into a reality.
So Vineet, my next question would be to you. Since ESG is pretty much at a nascent stage, are there any rules, regulations governing ESG in India?
So, being in the, I think, some of the highly regulated industries, I had worked almost 20-25 years of my career, rising from chemicals to what you call resource-driven industry, energy sector. First of all, I would like to say that ESG, environment or social or governance, all these things, laws were very well there. It's not something new. You have an environmental impact assessment right from 2006. You have lot of labor laws which are very specific on the from the perspective of labor development, human development, and all those aspects, safety and all that. From so many years, these are there. But what has changed basically? What has changed is the way we see those enactments, the way we see the business. We see a business not now only a set of financial metrics. We see it more as something which can impact my brand, something which can impact my reputation. These aspects becomes critical. And I would like to just give 1 or 2 examples, very small examples, and to explain how the approach and the accountability towards those laws or the dynamics have changed. If you see labor laws, there are provisions related to certain small non-compliances and all that. And of course, at my GC level, those issues didn't come. But the changing dynamics, how it changes is the way those if there is a non-compliance or if there is a small thing in the past, what used to happen? You go and get it compounded. It's a very small process. If there is a compounding is there, you go to the magistrate, and occupiers, whomsoever is the occupier, being a director and all that, it really say, okay, this is a routine practice, small laws and all. But now it's not the case. You have your LODR disclosures. You have your BRSR, Business Responsibility and Sustainability Report, where this thing comes as a disclosure. And now the thing is that the accountability changes, varies actually drastically. Now the GC has to see why this has happened. You go and check why this has happened. Occupier would be monitoring the things because it's a sizable reputation impact, even if it is a small blip, but it creates a challenge. I will give another small examples. I don't want to bother this forum with too many heavy things. Small example, land acquisition. Of course, it impacts community. Prior to 2013 Act, companies used to acquire land. It was not need-based. It was more from a financial ki aaj acquisition process is simple. Get and acquire it. Kal ko it will be required later. Abhi to let's go ahead and acquire the land. Because the process was simple, you have to go to the collector, you have to get one notification of section 4, section 6 and all that, and it's very procedural part, and those things are easily happen. Coming 2013, the way the land acquisition happened, now you have a lot of responsibility when you go and acquire a land acquisition. You have to get the community buy-in. The compensation is almost 4 times. How the compensation is determined is also drastically changed, not the discretion of the collector. So now you have to see, when there is a land acquisition proposal, it goes into so much of scrutiny. Do we need that land? What are the alternatives? How you look into that? So all these aspects have changed. Another example of cement sector where I am working, cement sector last 20 years, there is a lot of innovations have happened, because as it's a highly carbon emission and all that, those considerations are there. And industry, so how the two industries, one is the power sector and cement. Power sector generates fly ash and cement sector uses the fly ash. And how the dynamics have changed. Cement sector has introduced new ways to come up with composite cement, slag cement, other kind of cement where you mix almost 30 to 40% slag. So what happened? Power projects, environment clearance will not happen unless and until they provide the utilization thing. So both has to work together in a kind of a circular economy or waste and all that. So I think it's, what I am trying to say is that laws were very well there, but the disclosure, the importance which has come up from a brand and reputation standpoint, the things have changed. So you have a sustainability report, you have of course a BRSR and all that, all those things are there. Top, of course it's coming for top companies. Sustainability report is more from a Dow Jones index, all those indexes are there, where all these parameters, standards, we have to evaluate whether we meet those standards. So it has lot of sensitization has generated across the business community on the ESG. So that's why nowadays we are seeing, otherwise laws were very well there, only some kind of a right tweaking has happened to make it more linked with your strategic objectives. That's what I can say.
Thank you so much for that, Vineet. Some very thought-provoking insights. With SEBI's reporting frameworks in place, ESG disclosures or the lack thereof will definitely have an impact on commercial arbitration. And it'll be interesting to see how governance failures like ESG misreporting will really pan out during arbitration. Abeezar, my next question is to you. To what extent can arbitral tribunals legitimately consider ESG principles, particularly environmental and human rights obligations or labor rights, especially when the party's contract does not expressly incorporate them?
Thank you. So basically, as we all know, arbitration is, written contract. It arises from written contract. Now, in case the contract does not have any specific clauses with regard to any breaches of any ESR obligations, then the tribunal will find very difficult to actually look into those principles and impute them into their, into the hearing or into the awards ultimately. And given the fact that the arbitration tribunal is ultimately bound by the, the mandate that it has to decide a dispute which arises from the contract, my belief is that if that is not part of the contract, then it is not going to be possible for the arbitral tribunal to actually impute any principles of ESG into what they decide and what they ultimately award. Having said that, what is happening, whether consciously or not, the tribunal now, the arbitrations now that we are, appearing before, basically are in some sense already following the ESG principles. For example, now when you have virtual hearings, what the impact and effect of that really is that you are now not spending time or not using, you use e-briefs for example, you don't use paper, you don't travel for arbitrations, which basically means that you're going to be saving on the emissions that the jet planes actually emit. You are going to therefore indirectly, and I don't know whether consciously or not, do comply with these ESG principles, so to speak, in that sense. But to your question pointedly, if it is not part of the contract, then the arbitrator will not be able to impute those principles and actually make them part of their hearings or their award. Thank you.
So as Abeezar said, that it's only a contractual dispute which can be arbitrated. But sir, my next question to you, Mr. DeVitre, we have seen internationally and globally a lot of ESG issues being arbitrated. However, there's little progress in India. So what, according to you, could be the reason for this? Is this because ESG disputes often involve diverse and unrepresented interests? Is there a risk of privatization of justice in matters affecting public good, especially considering the fact that ESG issues largely have a character of rights and rem?
See, there may be many, many reasons why ESG in commercial arbitrations, and we are only focused on commercial arbitrations because ESG considerations can arise from various sources, from statute, from conventions, from investor treaties, etc. We are focused only on contractual commercial arbitrations for the purpose here. Now, as Vineet rightly said, in India, we've had a regulatory framework for many years in regard to matters concerning commercial matters. I'm not saying commercial arbitrations, but in the matter of commercial, we've also importantly had specialized tribunals dealing with these matters. Like you have your NGT, the National Green Tribunal, which deals with one part of what is ESG, environment. You have your social, your labor matters, your criminal courts in a sense. You have the NCLT, which deals with intra-company disputes, shareholder disputes, etc. So these specialized tribunals are one way in which you can have these disputes resolved. Now, in India, under the overarching constitutional guarantee under Article 21, we have always had the right to life with dignity, with a pollution-free atmosphere, environment, etc., etc. But the difficulty has been, from the arbitration point of view, that all this is in public law. All this is essentially against state action or state inaction. I think the challenge in India is to now transcend and to cross the bridge from a public law features of ESG to a private arbitration contractual dispute resolution. And to my mind, one of the reasons why it perhaps has not caught on in India as much as it should have perhaps is what I regard as the slightly uncertain situation, legal situation, which relates to the arbitrability of such claims. As Abeezar said, an arbitral tribunal has to act within the four corners of the statute. I don't quite entirely agree with his hypothesis that ESG principles and arbitral tribunal cannot apply. But when you consider what are the let us say matters which have been held to be non-arbitrable in relation to ESG, in relation to commercial matters, there is a long list, and I've tried to sort of prepare the list because now after the judgment of the Supreme Court in Avitel and in Vidya Drolia, which has not, this aspect not been dealt with in the stamp matter, what are the exclusions? Indian courts have tried to broaden arbitrability claims, even within the exclusions. For example, insolvency. You can't have an arbitration in relation to insolvency matters covered under the IBC. But in Kotak Bank, that Indus Bio, the Supreme Court said that no, you can have that to the limited extent that matters in rem are not normally arbitrable, as Murtaza said. But matters which are subordinate to matters in rem and arise in personam can go to arbitration. So what the Supreme Court said in Karnataka Bank, for example, is that a financial creditor can file a Section 7 application for a financial debt. The in rem part of that will come in only once the claim is admitted. Prior to admission, if the NCLT, for example, which is the specialized tribunal, comes to a conclusion that there is no default, it can refer the parties to arbitration under Section 8, if there's a Section 8. I happen to be in the losing party in Karnataka Bank. But the Supreme Court has extended this principle now to say that all in rem, all disputes before the insolvency court are not in rem. The in rem proceeding commences only once the dispute is admitted, and then you are bound by the in rem principle. Until then, an arbitration is permissible. So the Supreme Court has tried to carve out sections or carve out portions from the overarching non-arbitrability of in-rem proceedings. Take criminal matters, for example. Settled law. Criminal matters can never go to arbitration. What did Justice Nariman say in Avitel? He said that yes, criminal matters cannot go to arbitration, but the same breach may give rise to a criminal cause of action and to a civil cause of action. The civil cause of action arising from that breach, even if it involves a coordinate criminal action, nevertheless can go to arbitration. Again, it's a carve out, because you remember the days of the judgment in Radhakrishnan, which said that fraud can never go to arbitration. Serious questions of fraud can never go. Supreme Court has now said, no, that's not correct. Radhakrishnan has now been overruled. And the idea is to make it broader, arbitrability broader. But even within that broader framework, I feel that in India, the state of the law is a little uncertain. And remember that these disputes are to be referred at the Section 8 stage and Section 11 stage now on a prima facie consideration by the court as to whether it should go or not to an arbitrator. And the arbitrator, you have the second step where you, after an arbitrator decides under Section 16 or if he has to come back to court. So when a company or a corporate body starts an arbitration claim, it does so with a certain element of uncertainty as to whether that claim would be regarded as a claim which is incapable of being settled by arbitration in India. Remember that the Arbitration Act under 34(2) and under 48(2) also for foreign arbitrations and enforcement of foreign awards, all awards have to be passed through the gateway of this test. Is this subject matter capable of being settled in arbitration? And matters in rem, criminal matters, etc. Take for example child labor, which is one of the aspects of the social element of ESG. It may arise in criminal matters, but it may also arise from a contractual dispute where the investor says that you will not engage in any labor, in any practice prohibited by law, and there is a breach. There may be reputational damage, etc., which we'll deal with separately. But it is possible that if you go to an arbitration, the arbitrator may come to a conclusion, yes, I have jurisdiction, because very few arbitrators like to say they don't have jurisdiction. But when you come to court, a court may well find that this is hit by Section 34(2), because this was a subject matter which was incapable of being decided in arbitration. So these, to my mind, are the kind of barriers which may come in. Take greenwashing claims. You know, greenwashing is where there is a fraudulent misrepresentation. Now, that fraudulent, as to whether that the disclosures have been made, compliance has been effected by companies under what was referred to as the BSR, the SEBI regulations now, the LODR regulations, etc. Now, these greenwashing claims, to my mind, can go to arbitration, because they are no different from a fraudulent misrepresentation in other contracts. And now, of course, the Supreme Court has said that the fraudulent misrepresentation must, if you are not to go to arbitration, it must relate to or affect the existence of the contract, namely at the time of entering into the contract. The fraudulent claims which arise in the course of performance of the contract are always arbitrable now. Again, a refinement of the earlier law which, oops, no fraudulent claims, sorry, that was not intended for you. So I feel that the uncertainty of the law in what is referable to arbitration or not is a major hiccup when it comes to whether you can go, because these are all commercial disputes, yes. But you have to bridge the gap between the public law and the private law aspects of it.
Thank you so much, sir. It will certainly be interesting to see how the jurisprudence evolves. The principles of ESG, which were once seen as peripheral, are now central to how businesses operate, invest, and also resolve disputes. And it's a lens through which investors, regulators evaluate long-term value of businesses and also their ethical conduct. My next question is to you, Saurabh. From a corporate counsel perspective, do you feel ESG obligations are influencing contract drafting as well as negotiations?
Thanks for the question, Amrita. Yes, see, now, like sir has explained that how the interplay is, that all issues which are in REM might not be arbitrable, but a subset of it is. Now, see, ESG has now become something which is a mandate from, SEBI's standpoint, right? Before that, it was, before even CSR came into 2013 Act, which was mandated, it was voluntary. How have contracts evolved from pre that era to today? If you see general example, if I give you a construction contract, if I give it to a contractor, where, I tell him that you please construct a building, maybe 60 floors, deliver it to me in what, 3-4 years period, 5 years period. There are a lot of insertion of new provisions that we are also doing, we are evolving, day by day, where we obligate the contractors to ensure certain standards of, environmental impact that they create, certain standard of social impact that they create, how they will deal with laborers, how they will be, stationed, they will be living, their conditions, their food, everything that we are, now incorporating in our contracts, whereby we are making them obligated to take care of certain things, which should be bare minimum as a ESG standpoint. Now, of course, contracts have evolved a lot. This is one aspect which I told you, which is a construction contract. Now, if I buy a land today, right, there are a lot of provisions which are being incorporated as anti-bribery, anti-corruption, PMLA. All these are governance standpoint where we do take those representations which maybe, long back we were not. Now, from these standpoints, contracts have evolved. They are further evolving, and with the rapid change in this, scope, we will of course change a lot in coming time. Like, sir explained how arbitration, helps. I would also want to add to one example, sir, in it, that environment impact when you create, the concept is polluter pays. Action will happen against you, okay? Now, assume there is a contractor who's in place. I have given him, a job to do. There are obligations in my contract which he has breached and not done, and hence the agencies are after you to affix the accountability. But there is a contract now where there was obligation which is breached, right? Now there is arbitration which is possible, and now how this subset will work from REM to, in person. Yes.
Thanks, Saurabh, for that. Vineet, I'll ask you the next question. How are companies building contractual clauses with ESG aspects in focus?
Again, so I'll start with an example, let's put it this way. So again, of course, I do agree partially with the concept of REM and all that. That's very straightforward. In fact, in my career, I've also handled bilateral investment treaty related arbitrations in international jurisdictions, etc. Because of investor versus state cancelling certain rights and against going that. See, first of all, I would like to say that the one form of arbitration, so you enter, just take an example, you enter into a share purchase agreement, which obviously will have an arbitration clause. You execute the agreement on the date of execution, and now there is a time period in which all the condition precedent has to be met, and there is a closing. Under this share purchase agreement, there are two clauses. One is specific indemnity, another clause is material adverse event. Now, how the dynamics change, you see. On the date of execution, you have gone with an understanding that of course, the company, whichever you are investing, it has a mineral resource, and there are certain licenses issues which are there. 2018 Supreme Court in a common cause of matter has come up that all the mining leases has to have an environment clearance under 2006 EIA. What does this mean? 2006 has introduced a public hearing concept. So if you don't have it, then you have to revalidate it. Plus, in case you have done certain non-compliances, Ministry of Environment came up with a circular saying that we will evaluate and we will put some environmental compensation. So you enter into this SPA with an understanding that there may be an indemnity which may come in future, and you put a good clause on specific indemnity. And you have a material adverse event clause also. Now by the date final closing happened, there is a One Shakti judgment which came, which said that ministry has no power to condone and all that or impose penalty. So no environment clearance can be post facto. So that means what? it has transformed into a material adverse event. And now the question would be there, the dynamics of the dispute would be whether it is a change in law or it is, because of course there was earlier judgment and so on. So this kind of a dynamics is going to happen. I think law is evolving. Again, another example I say, maybe not under the Arbitration Act, but in the labor law, there is a kind of a mediation come arbitration kind of a procedure. With all your concept of industrial settlement under section 12(3) of the Industrial Dispute Act. What is this? This is a kind of a area where you do kind of a settlement. First you go for a settlement. If the settlement doesn't happen, you go to a conciliation. And if the conciliation doesn't happen, then a reference has been made to a industrial tribunal. So this is basically one form of a dispute resolution mechanism. Another way, of course, I just started with these couple of examples. I have been in the oil and gas industry. So again, under the production sharing of contracts, there is a clause of good international in the petroleum industry practice. And that clause in the agreement, all the agreement, even though you cannot go and enforce that particular clause, but when you go for your claims, your cost recovery, your damages, this clause comes and plays an important role. Again, how the companies are now changing in the dynamics is ESG clauses used to be there, clauses were there, but again now the dynamics is that now you have, when you select a vendor, you have those parameters you see, whether he meets those parameters. So that becomes an important way. The second thing is the scoring, because when you impose your liquidated damages, your other, ESG scoring also now matters a lot in big projects, because it's a matter of all reputation, because ultimately if a contractor doesn't pay its subcontractor, in turn a subcontractor doesn't pay its labor, the impact, what will come in the newspaper? It will come, so an XYZ company has not paid its vendor. It won't come that a contractor, small time contractor has not paid. So that responsibility matrix, that governance system, mechanisms, etc. has come up. Of course, data privacy, all other aspects are there. Again, one of the arbitrations which is in the cement sector, which is actually, which has an element of ESG, as I mentioned, the fly ash and a slag lifting contracts which are there, where there is a symbiotic relationship between power plant and the grinding unit of a cement company. So they promise that you allot me, give me land, I will give you the fly ash and you have to evacuate fly ash. So now the question which comes is, there is a clause related to penalty. If you don't lift it, you have to pay this much penalty. Now, the way now we are seeing the arbitration dynamics is that this clause is, whether it's an LD clause, genuine, predetermined loss and all that, or it's in the nature of penalty. And the way the tribunals are now interpreting this clause is a strict liability, kind of strict enforcement. So sometimes you see, just because I have not lifted fly ash, I will be imposed such a heavy penalty and all that, and the tribunals are upholding that, because they are seeing the whole dynamics that you have promised certain investment and they have given you a evacuation right, and if you don't evacuate, ultimately this fly ash has to be dumped, which will have a societal impact and all that. So those enforcement mechanisms are coming up, are there. But it's evolving stage in the Indian arbitration jurisprudence, unlike, but I see maybe 2 years, 3 years down the line, once these investors or the management may have to face arbitrations when these sustainability reports, if the disclosure doesn't meet and all that, the accountability, enforceability of VRSR or sustainability reports. Maybe investors may take arbitration route and all that if the companies do not meet those targets and all that. That could be a situation which may come up. But the bigger problem is how you need expert tribunal to look into that. You need evidence. The evidence is very different level of evidence is required. It's a very technical subject. And of course, how you quantify the intangible damages. So all those aspects are there. But yes, clauses are evolving in the contracts.
Thank you, Vineet. So interesting discussion. So Freddy sir, I'll ask you the next one. as he rightly said, there are few challenges. So we would like to know what challenges are likely to be faced while dealing with arbitrations relating to ESG disputes. For example, if you have an environment dispute or some dispute, how would the arbitrator really quantify damages? Is there a standard for quantifying these damages?
It's a difficult question to answer because essentially you're asking how do you quantify what may be intangible damage or intangible loss. Now, I think the answer to that really depends on what kind of damages you claim, because ESG breaches can give rise to a variety of claims, including performance, etc. But at the moment we are on damages. Now, what are the kinds of damages that can arise in the case of an ESG breach? As Vineet rightly said, one is a reputational damage, where you are looked upon by the world as having associated yourself with a person or a company which has not adhered strictly to the law and which he was required to adhere to by reason of the contract between you, apart from the law. I mean, the law is mandatory, but also he entered into a contract with you saying he will not do X, Y, Z, which is prohibited, and he does it down the supply chain, up or down the supply chain. Now, you may be tainted with the same brush as an investor or financer financing that project. Reputational damage, I think, can be assessed because you must realize that damages may be monetary, have to be monetary, but there may be non-monetary reliefs also possible in ESG breaches. Now, as far as monetary breaches are concerned, reputational damage, if you want to assess it, I would, as a lawyer, assume that the same principles that would apply generally to, say, defamation would generally apply to reputational loss. Because eventually, what is reputational loss? Your standing in society as a corporate. Of course, it may affect your profits, which is a separate head of claim. But reputational loss may be decided or quantified on the same principles as you would have defamation losses. Generally speaking, I would say that the principles underlying our Section 73 of the Contract Act, which has withstood the test of time for so long, generally I don't see why those principles can't underlie also the quantification of damages in ESR breaches. And take, for example, what are the likely other breaches that can arise in the case of, I've just tried to tape it out so that we can proceed with this quicker. One would be, as I said, reputational, greenwashing claims, as I mentioned. What are greenwashing claims which arise in ESR? As I said, fraudulent misrepresentation. Now, fraudulent misrepresentation is not specific only to ESR contracts. Fraudulent misrepresentation, you have had cases in commercial matters broadly. So you have had processes by which you can quantify these misrepresentation claims for greenwashing. There are many greenwashing claims which come up where a party at the time of entering into the contract represents that he is compliant with XYZ law, and then you find that that disclosure was fraudulently misrepresented, or the extent of the compliance was not properly done. So even greenwashing claims, to my mind, can be quantified on the application of general principles of damages. Remediation claims may arise. Remediation in the sense that, as Vineet mentioned, somebody down the supply chain has agreed with you that he will, or a builder, the example that Saurabh gave. A builder agrees with you in a project that he will give you 5 acres of forest land. Why? For the benefit of the purchaser as well as for the benefit of the community. He doesn't do it. What do? Either remedial or restitution. Now, remedial would mean if he didn't do it, so you are forced to do it because you have to comply with the law. Again, those costs are quantifiable. It is in India we have had a very vibrant judicial intervention, many interventions in forest matters, in cleaning up of river matters, in water source prevention matters. But all those have been, as I said, in the public law sphere. Here we are talking of damages claimed in personam really, by the individual concerned who has suffered that damage. So under all these heads, to my mind, there is no reason why you can't. Valuation may be a problem, what to value. But there also, there are now international valuation standards which have come in for ESR cases, which the market approach or the income approach or whatever, the normal accountancy. And I'm sure those will come into India also effectively. So to my mind, these are matters which, there is a very interesting case, for example, where a group of Indian farmers sued IFC, the International Finance Corporation, because they financed a coal-based project in Gujarat, which then, in the functioning of the project, it started contaminating the fields around and polluting, etc., etc. So they sued, brought a class action in America. And there, of course, they claimed sovereign immunity as a state, and the American Supreme Court said no. So the trial is probably ongoing. But these are, in such a case, it will be difficult, I assume. But an arbitrator who is dealing with commercial matters, ultimately the rupees, annas and pies can always be computed. And one interesting thing where perhaps what Abeezar also touched upon, an arbitration tribunal, to my mind, is entitled to apply, for example, the polluter pays principle. Because even in in personam damages claims, so far polluter claims, polluter pay principles have been applied where the community has been damaged, where there has been damage to public property, etc. But I see no reason why that principle can't be applied when you have environmental damage in an ESG commercial arbitration.
Thank you, sir. With ESG clauses now increasingly being embedded in commercial contracts, shareholder agreements, and investment treaties, arbitration is indeed emerging as a vital forum for resolving these complex, multidimensional disputes. As Vineet also pointed out, it will be interesting to see what evidentiary challenges would arise when parties allege environmental harm, and it will be interesting to see cases wherein scientific data itself is contested. My question to you, Abeezar, is, should arbitrators possess specific knowledge or expertise in ESG matters? And if so, then how would arbitral institutions address this in the entire appointment process? Also, do you see eventually there being specialized arbitration rules for ESG arbitrations and maybe even a dedicated arbitral tribunal?
So I think there can be no dispute with the fact that specialized knowledge is very important, and ESG in fact is a specialized niche field, and therefore anybody adjudicating on that, having that knowledge would definitely help in having resolving the dispute basically. Having said that, as my co-panelists have all mentioned, the laws which uphold the principles of ESG are not new. And for example, for environment, we have the NGT, we have, for example, for labor, we have specialized labor courts. And on the governance side of it, we have the Companies Act, disputes arising under that go to the NCLT. Now, therefore, to carve out these disputes to go for arbitration will be a challenge. So I think the call will have to be taken at some point of time that are we going to have a tribunal set up to deal with the ESG disputes, or are we then going to allow them to go for arbitration? And if they go for arbitration, then those disputes which already are going to these specialized tribunals, what happens to them then? So I think the challenge, so I think to answer your question, yes, definitely, if we are doing the arbitration mode, we will have to have, or we should have specialist arbitrators who are specialized in the ESG principles and concepts, because specialists can always, I think, render better, judgments or awards, as the case may be, knowing the subject and being a specialist in this particular subject. Now, in terms of the way forward, if the decision ultimately is to go towards arbitration as being the forum to resolve these disputes, then you have to start, educating those specialized arbitrators who volunteer to, of course, be in this particular field. And I think having sessions with them, educating them on the principles would always be a good idea. So the way forward, I think the major decision really is that when we have these disputes, whether they go to arbitration or go to a specialized tribunal, and if arbitration is the preferred option ultimately, then educating arbitrators, giving them, special classes so to understand this law or this process even better is definitely a preferred option.
So just speaking of challenges that are being faced in arbitrations, Freddy sir, I'll just ask you this question. Do ESG-related foreign-cited awards pose special challenges for enforcement in India?
Sorry, you were asking me the question.
Yes.
Oh, sorry.
I think it would depend on the nature of the foreign award. If it is a monetary award, although arising from an ESG breach or involving issues of ESG and considerations of ESG, if it is a monetary award, then it would not face any more difficult challenge than any other monetary award under the foreign of a foreign award. The problem may arise in cases where foreign awards deal with non-monetary aspects of ESG. In such cases, to my mind, that award which deals with these non-monetary aspects, and whether environmental, social, operation mismanagement, share transfers, etc., those awards will necessarily have to comply or be shown to comply with Indian law on the subject. And if they don't, because remember, there are at least 3 provisions in the Arbitration Act, which, as I'm sorry to repeat it, but which make it very clear that the subject matter of the arbitration, the subject matter must be susceptible to arbitration, must be capable of being resolved in arbitration. And in non-monetary awards, very often the subject matter will be general environment concerns, carbon credits or emissions, etc. So those would then necessarily have to comply, I think, with Indian laws. And in that context, it may be interesting to see that, for example, in the case of shareholder disputes, where party A has agreed to sell to party B, maybe under an investment, maybe under whatever, and there is a foreign award saying, now you have to come here, have your award held to be enforceable under 48. But as the Privy Council has often said, in India, problems arise at the execution stage. Because Privy Council said it many, many years ago. It's like starting a new litigation when you want to execute something. And the Supreme Court in Cheran Properties took the view that in such a case, if the company does not register and you have to then go and get relief for execution, you can directly then apply to the NCLT, because the NCLT is the body having exclusive jurisdiction in these matters. So foreign award maybe have to be executed through the agencies of these specialized tribunals, whether it's NGT, whether it's NCLT, and as Abeezar said, these are all special bodies. So one of the disincentives for arbitration may well be that, look, there is supposed to be an expert, a specialist domain expert on these specialized bodies like the NGT or the NCLT. You are paying much less. So why can't you regard this as some form of government institutionalized arbitration and give up your right to party autonomy in the question of appointing arbitrators? It may be a sort of rival to private arbitrations. Because most of these, like, for example, DRT, the Supreme Court has said debt recovery claims cannot go to arbitration in Rolia. So also, as I said, insolvency, etc. So maybe in India, people will veer to the specialized tribunals which have been formed. And therefore, if, for example, the award involves foreign exchange, it may be possible that after the court has held it to be a final award, that's the preliminary step, you can't avoid 48(2). But after the court has held it to be enforceable, it may be possible that you have to go to RBI, for example, for sanctions, for permissions, etc. And it's a question which the jury is out in that sense. Can a regulatory authority in India frustrate a foreign award? To my mind, the answer is no. But I mean, I know Docomo dealt with it in a certain way. But it's interesting because when you come to enforce a foreign award in India, these are considerations that may arise in ESR proceedings and which are specific to ESR proceeding. I think foreign awards can, in regard to ESG matters, or to summarize, can be enforced like any other award, subject to this one overriding consideration which I say and which I repeat, that the foreign award, the subject matter must be capable of settlement in accordance with the law in India, because that is the requirement of 48(2). So whether the law in London does it or in the UK does it or allows it, if the law in India prohibits something, then I do not think that foreign awards in ESG matters are enforceable in India.
Thank you so much. I think we are running out of time. We'll ask the audience if they have any questions to our esteemed panelists. Yeah.
Yeah. Good afternoon to all the panelists. My main question is that pertaining to valuations or determining the quantum of damages when it comes to ESG considerations, if any legislative framework that can come up or any rules that can be prescribed by the government, what should be developed and how it should be developed so that it becomes easier for the arbitrators to determine the quantum of damages pertaining to specific type of ESG claims?
I presume I hope I'm not being presumptuous in understanding that the question is addressed to the person who dealt with the valuation point. But unfortunately, we don't have a chartered accountant on this panel, because that question may well be answered best by a person more acquainted with chartered accountancy principles for valuation purposes, etc., or a valuer. But broadly, as I said, there are now emerging international standards of valuation. And those, when you examine those, really those valuation standards are in a sense no different from how you would value claims arising from breach of contracts for refusal to transfer shares or some such claims like that. So I assume that the Indian Institute of Chartered Accountants will come up with some Indian standards of valuation that should be done. It would be a useful guide. But at the highest, it will remain guidelines. Ultimately, these standards will be a sort of evolution of the existing standards which are applied in cases of valuation to non-ESG matters. So, I mean, there will be separate standards for ESG, but they will be built upon and will be based upon existing standards for. I don't see any major deviation from those standards. Would anybody, Vineet or?
Just want to add, so like for example, environment compensation. There is in fact what you call central body, Central Pollution Control Board. They have come up with a very formula for determination. It has certain factors and all that, that formula is uniformly being applied. Similarly, as the sir has said that there are international IFRS sustainability standards are there, but Indian standards are not there in this regard. So of course, and even in fact, it will take its own time to develop. I think it's specific regulatory bodies are coming up with standards of computation and all that. Those things are there. Even if you go for a, let's say, it's not exactly a damage, your entire rehabilitation, when you acquire a land, entire rehabilitation policy, R&R policy which we call, that has certain standards actually on what base that compensation has to be determined. So those certain things have been standardized, but of course day-to-day damages and all that in the arbitration, those standards are not.
Thank you, sir.
Thank you so much.
Murtaza, this gentleman.
Yeah.
Good morning to all the panelists and the moderators. It was very enlightening and very good to discuss on the ESG considerations in commercial arbitration. My name is, I'm Chand, I'm coming from Andhra Pradesh, from Visakhapatnam. So my rather question or my observation on the ESG front considerations are that hope that in order to see that these arbitrations and all, are we really having something called as the ESG audit, like that of the financial audits of the chartered accountants, where you can really see that there is a, whatever you're saying, whether that is being effectively coming out or not, instead of giving lot of things we should consider ESG and all that, whether the audits with respect to the environment, with respect to the social, with respect to the governance, that is the most important thing, where in that angle, if I have to add, the human rights, the morals, the ethics, these are the things when they are being effectively brought in the minds of the society, in the minds of the people, then really these kind of arbitration cases of mediation or alternative dispute resolutions, whether they are year after year, what is the responsibility of the legal system or the ADR system to reduce those things, whether it is reducing or if they are increasing, that means, is it effectively been what all is said is happening or not? Because any industry, when we are checking its performance, we have this corporate social responsibility, all these things are in order to increase the social, cause. Similarly, in the system of law, the audit where year after year, it seems that in India, we have plenty of disputes, plenty of conflicts. They are increasing year after growing. You can say it as, year over year, they are increasing. That means they say that because of the cases pending, because of the economical growth of the country, because the industries are growing, so there are more and more number of disputes and all. But then, on the contrary, what I want to ask is that if at all we are really bothered about this ESG or the setting right of the human rights and other things, whether these things are disputes are coming down, or whether they are stagnant at least, if not going up. But my observation is they're growing like anything. They're multiplying, and then the cases which are pending are, if I'm not mistaken, more than 5 crore cases are pending. All these things are detrimental towards the growth, in the moral growth, or the kind of things which are talking about the good governance and societal or for the environment. This is the main concern. Today we are in this forum of discussions where we are more interested in these commercial arbitrations where people are, I'm sorry to make this kind of a statement, but the more the number of cases, the more the sustenance of every one of us, though we call it as noble profession. On the other contrary, on the other hand, we are seeing that they are growing. What we are trying to do, but really, is it happening is my question. Thank you very much. Sorry for a lengthy question.
Just want to add, you are absolutely right, the audits are important. Sectoral wise, this is very evolving. Let's say giving energy audits, particularly in certain sectors. Just 3 days back, there are environmental audit rules have been notified. In fact, I would say, let's say power sector, the RPO compliance, renewable power obligation compliance, that initially it was litigated, industry says why it is required, this, that and all that. But the courts have remained firm actually, even up to Supreme Court and all that. And those areas, certain sectorial areas, the things are improving actually, and litigations are coming down. So you won't find much litigation now on the RPO obligation, despite the fact that the government is every 3 years, government is increasing your RPO, basically your renewable power purchase obligation as compared to your thermal energy and all that, that obligation. So that initially people were litigating, now it's not. Similarly, when it comes to the green bench related matters and all those things, all those areas related to eco-sensitive zones and all that, Supreme Court has come up with certain principles and all that. Now the litigations have come down actually. Of course, those persons whose industry had got impacted and all that, they will go and fight it out. But the fact of the matter, things are changing. But there are a lot of sectors where it has to, yes, still to catch up. I would just try to add.
Just as a preliminary observation, before answering what I believe was the question you wanted to ask, I think you have made out a very good case, with due respect, for inclusion as a panel member at the next conference. I'm only saying that in a lighter vein. But, one interesting thing strikes me. Of course, there are energy audits and all these audits. But your question will raise one important aspect. Maybe it's time we had arbitration audits. And maybe the MCIA, who is represented here by Nidhi and others, maybe the MCIA can initiate it. Let's find out how green are arbitrations in India. Abeezar touched upon it in some way. But an arbitration audit, apart from a business audit or an industry-wise or a segment-wise audit, might throw up very interesting answers. To what extent, for example, are we dispensing with paper? I mean, I remember doing an arbitration in Delhi, an international arbitration in Delhi, where we had 2 Indian arbitrators and the chairman was an arbitrator from London, Ian Black. And believe me, we were at the Oberoi in Delhi. A hall about the size of this room, every conceivable wall was covered with records and paper records, where we had huge tons. All of us had sort of volumes and volumes and volumes. And what did the chairman have? He used to come to the arbitration with one Surface Pro. That was all. The entire record was in that one Surface Pro. It was one of the most, let me call him the greenest chairman that I have seen. But that kind of an audit and maybe in arbitrations in India can now tend towards dispensing with and going online, as Abeezar said, or using methods which would make arbitrations greener in India. That your question may take us into that new avenue. It's for the MCI and other institutional arbitration forums to really take the initiative on that aspect.
Thank you, sir. Just to add, last point is that because of these more number of cases of arbitration, and because of more companies involving into this kind of conflicts and disputes, indirectly, in fact directly I can say, the cost of the products, the cost of the services definitely increase because arbitrators are not coming free or cheap. They are very expensive. At the same time, the companies which are getting into those conflicts are very much expensive because of these conflicts and all. Millions of dollars are getting into it. And this is ultimately going on whom? Going on the country. That means on the people. So my worry is that it should be reduced as much. They have to have a scale. They should have an audit where these things are coming down or not. Otherwise, all our efforts is not going to come to the rescue of the nation. Sorry. Thank you very much, sir.
Some very interesting perspectives shared today. Thank you, everyone. Thank you to all our panelists for their rich perspectives and also a gracious audience for your engagement and participation. From this discussion, it is clear that ESG is now no longer a corporate buzzword or just a compliance checkbox. Rather, it is a catalyst for ensuring that we draft our contracts, manage risks, and resolve disputes, keeping in mind all of these considerations. As India continues to attract global investment and also asserts its position in the international arbitration scene, integrating ESG considerations is no longer just prudent, it is imperative. The future of commercial arbitration in India will be shaped not only by legal innovation, but also by a collective commitment to sustainability and justice. Thank you once again, and I will only request that let's keep the dialogue going on beyond this room. Thank you so much.